Okay, again, thank you for the executive session participation on all counts. We'll now move to the public session and we'll proceed through the agenda as indicated on the document you received. The first step will be to consider the consent calendar, which includes items 5 through 18, as I read the agenda, executive.
Correct.
For the moment, that's the okay, colleagues, the approach here is to see if anybody wants to pull an item off of that consent calendar before we act on it. At the moment, hearing and seeing none, will proceed. The vice chair will motion, please, on the consent calendar. Items 5 through 18.
Mr. Chair, I move that the commission approve the consent calendar as presented.
For the motion, colleagues, any questions? The administrator will call the roll on the consent calendar for our public session. Please proceed.
Commissioner Thompson.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Jancy.
Aye.
Commissioner McCauley.
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Thank you. Following through the agenda, the time now arises for consideration of lobbyist penalty correspondence issues presented by the executive director. Item 19 first and onward, please.
So item 19 is a request for a reduction in penalties from lobbyist Lizzie Atwood Willis. Her explanation is there were issues with email notifications. This is her third violation, and per our sort of matrix, that would be a reduction to 25% of the violation or $50 minimum. And so our recommendation in this case is $150 penalty.
Thank you, colleagues. We'll consider these items, we'll act on these individually. At one point, we toyed with the possibility of putting all these together in some form or fashion. Felt the best approach was to consider these individually down through whatever number it is. I have a general question, executive. If this is the best time, I'll ask it. Can you generalize for us the process you used to reach reduction proposals, recommendations for us?
Yes, so this was a process that Ron had established previously, and that is when it's a first violation, we would recommend a letter of education. For a second, 10% or a $20 minimum, a third, 25% or a $50 minimum, fourth, 50%, $75 minimum, fifth, 75% or $100 minimum, and no reduction. The only change that I have made to this is that if they had prior violations, but they were all simply paid without asking for waiver or penalty, then my recommendation would be to reduce the penalty by 50% or by a step, basically. So there are cases where this might be their fifth or sixth violation, but all prior times they had like a $10 or $20 penalty and they just so that is what I am applying when I am making my recommendations for reduction.
Thank you. Any questions for our investigator, for our executive based on my question? Hearing and seeing none, the time comes now for action on item 19, Vice Chair.
Mr. Chair, I move we accept the recommended penalty in the case of Lizzie Atwood Willis.
Appreciate the administrator will call the roll. Item 19, please.
Commissioner Thompson.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Jancy.
Aye.
Commissioner McCauley.
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Colleagues, staff, let's watch for their potential return at some point of Commissioners Mason and Burke, who were off on doctor's appointments briefly and indicated their intent to return. So we'll watch for that. We'll move to item 20, executive.
Yes, lobbyist Gary Fisher. This is an example where it is his fourth violation. He previously paid the penalties on his prior violations. So the current penalty is $500. that would recommend a reduction to $125. In this case, I would draw your attention to his explanation for why he was late with his Q1 filing or Q4 filing. He explained that he had an unexpected stroke in December and was out of work and therefore did not get his filing done.
Thank you for emphasizing that to us. I appreciate it. Any questions about this matter, colleagues? Hearing and seeing none, Vice Chair, item 20.
Mr. Chair, I move we accept the recommended penalty of $125 in the case of Gary Fisher.
Administrator will call the roll, please. Item 20.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson.
Aye.
Chair Fiscum.
Aye.
Motion passed 5-0.
Thank you. Item 21, executive.
Yes, this lobbyist had one prior violation that was paid. He incurred penalties of $20. Given its second violation, the minimum would be $20, but because he paid his prior penalties, our recommendation is to reduce it with $10.
Thank you, Vice Chair.
Mr. Chair, I move we accept the recommended penalty of $10 in the case of Aaron Hunt.
Administrator will call the roll, please. Item 21.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson.
Aye.
Chair Fiscum.
Aye.
Motion passed 5-0.
Thank you. Item 22, executive, please.
This lobbyist, there are penalties for two separate quarters. The first one was only a $10 penalty, which is the minimum, so no reduction there. The second one for Q1 of 25, the penalties were $950. The recommendation as its fifth violation would be to reduce it to $425.
Executive, how many violations have in total does this person have?
They previously had received two separate letters of education
Okay.
and then paid penalties twice on top of that.
Thank you. Questions, colleagues? Hearing and seeing none, Vice Chair, please. Item 22.
Mr. Chair, I move that we accept the recommendation of $10 for the 2024 penalty and $425 for the 2025 penalty in the case of Paula Leslie.
Thank you. Administrator will call the roll. Item 22, please.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscum.
Aye.
Motion passed 5-0.
Moving on, colleagues. Item 23, executive.
Yes, this lobbyist, this is a second violation. Prior violation was paid. The recommendation is to reduce the penalty from $70 to $20.
Administrator will call the roll. Pardon me, Vice Chair, item 23.
Oh, I'm sorry. I was looking at Susan's. She can't make the motion.
No.
Mr. Chair, I move we accept the recommended fine of $20 in the case of Sarah Levin.
You've heard the motion, colleagues. Here's the question now. Administrator will call the roll. Item 23.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscum.
Aye.
Motion passed 5-0.
Thank you, colleagues. Item 24, executive, please.
Yes, for this lobbyist, the had two prior violations that were penalties were paid. He then had two additional violations, which were $10 each for Q1 and Q of 24 and Q4 of 23. The recommendation is no reduction there. And then the final violation was Q1 of 25. He accrued $950 in penalties. Recommendation is to reduce that to $425.
Thank you, Executive. Did this individual remind me, have any suggestions as to why he is missing billing deadlines?
It was email issues, didn't get, he left the job, took a new position, didn't have access to email.
Mr. Chair, I move that
Please.
we accept the recommendation of $10 for the 2023 penalty, $10 for the 2024 penalty, and $425 for the 2025 penalty in the case of Quinn Reed.
Thank you, Vice Chair. You've heard the motion, colleagues. The administrator will call the roll. Item 2-4.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Thank you. Item 25, Executive.
Yes, this lobbyist had one prior violation, incurred penalties of $10. The recommendation would be no reduction as that is minimum.
You, Vice Chair, please. Item 25.
Mr. Chair, I move we accept the recommended penalty of $10 in the case of Amanda Sullivan Astor.
Administrator will call the roll, please. Item 25.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Moving on, colleagues. Item 26, Executive, please.
This lobbyist had a prior violation and received a letter of education, was 1 day late and therefore incurred penalties of $10. Recommendation is no reduction. Leave it at $10.
Thank you. Vice Chair, please. 26.
Mr. Chair, I recommend that we accept the recommended penalty of $10 in the case of Dave Van Hoff.
Heard the motion. Administrator will call the roll, please. Item 26.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Thank you, colleagues. We will now forge ahead to lobbyist client penalty correspondence issues also presented by our executive. The first item is number 27. Please proceed.
Chair Fiscom, I would note that Dan Mason appears he may have rejoined.
Commissioner Mason, are you back?
No, Chair Mason is not, or Chair, Commissioner Mason is not online.
Okay.
Okay, we'll just watch for both Commissioners Mason and Burke when they get back, if they get back from their appointments. Okay, item 27, please.
Yes, this is the lobbyist client employer, the Association of Oregon Faculties. They incurred penalties of $400. This is a third violation. They paid all their prior penalties, so the recommendation is reduction to $100.
This organization did pay its past, is what
Yes.
you have said for the record. Thank you. Any comments, colleagues? Vice Chair, please. Item 27.
Mr. Chair, I move that we accept the recommendation of $100 in the case of Associated Oregon Faculties.
You've heard the motion. Administrator will call the roll. Item 27.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Item 28. Executive, please.
This bike pack, this is their fourth violation. They paid their 3 prior violations. And so the recommendation is to reduce it from $550 down to $150.
Comments, colleagues? Vice Chair, please. Number 28.
Mr. Chair, I move that we accept the recommendation of $150 in the case for bike pack.
For the motion, the administrator will call the roll. Item 28.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Forging ahead, item 2.9, executive.
It's the National Association of Social Workers. Back in 2016, they had 2 violations that they paid. They currently, for Q1 of 24, they accrued $100 in penalties, and Q1 of 25, $2,900. The recommendation is a reduction to $25 for Q1 of 24 and a reduction to $725 for Q1 of 25.
Remind me, this organization has paid its past fines.
Correct.
We have any idea of why this organization is incurring further penalties?
They explained that the staff that were in charge of filing had been leaving, so it was staff turnover.
Okay.
They have a new person in who is trying to fix their process.
We will hope they're successful. Vice Chair, item 2.9.
Mr. Chair, I move that we accept the recommendation of $25 for 2024 and $725 for 2025 in the case involving the National Association of Social Workers.
Administrator will call the roll, please. Item 2.9.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson.
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
The colleagues, item 3.0, executive.
Yes, the Oregon Recovery High School Initiative has 3 current penalty violations for Q2 and Q4 of 2023 and Q4 and Q5 of Q4 24 and Q1 25. This entity has had prior violations and has received both letters of education and reductions by the commission. Therefore, my recommendation is for the 2023 Q2 and Q4 is no reduction. That would be a penalty of $20 for both quarters. For Q4 of 24, we would recommend a reduction to $3,750. And for Q1 of 25, no reduction because that would be their 6th violation.
Any explanation by them in their communication with us about the reason for these violations, plural?
The email that they were using had stopped functioning and they did not update it in the system, but they had a different email to use.
Comments, colleagues? Hearing and seeing none for the moment. Item 30, Vice Chair, please.
Mr. Chair, I move we accept the recommendations of $10 each for the 2023 violations, $37.50 for the 2024 violations, and $800 for the 2025 violations for the Oregon Recovery High School Initiative.
Thank you, Vice Chair. Administrator will call the roll. Item 3.0.
Commissioner Jancy, Commissioner
Mr.
Jancy,
Mr.
Aye.
Jancy, thank you very much, Mr. Jancy. Thank you. Please proceed.
Commissioner McCauley,
Aye.
Commissioner Thompson.
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Proceeding forward on, colleagues, item 31, executive, please.
Yes, this lobbyist client employer heard a $20 penalty for Q1 of 25. It was their 2nd violation. They had paid their prior violations, so my recommendation is to reduce the penalty to $10.
Thank you. Vice Chair, please, item 3.1.
Mr. Chair, I move we accept the recommendation of $10 in the case of Union Pacific Railroad.
Administrator will call the roll, please, item 3.1.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Thank you, colleagues. We will now forge ahead in order with the statements of economic interest penalty correspondence, again presented by our executive. Item 32, please.
Yes, item 32 is Jamie Adelberger, a planning and zoning commissioner in Harding County. So there were 3 violations. Had been no prior violations. Three violations for filing SEIs late in 23, 24, and 25. The recommendation is for the 23 SEI to waive that and provide a letter of education. That was the 23. For 24, it was only a $10 penalty, so no reduction. That's the minimum. And for the 25 SEI, to reduce it from $110 to $30.
Thank you. Executive, was this the matter that involved the flood? If
Yes.
I'm saying that properly?
Yes, for the 2025 SEI, Jamie Adelberger explained that they were impacted by the Harding County floods in this spring.
Is there any rationale to go to 0 for that one in light of that?
That is well within the commission's discretion.
Comments, colleagues? I was just persuaded as I read over this material in the last couple of days that issue of the flood and the reality of a flood, which could occur elsewhere than Harding County alone, might be a rationale to go to 0, but I'm not trying to advocate that unilaterally. Questions? I mean, the dislocation of a flood means you can't hardly do anything other than leave. You could make the same comment, I suppose, about fires when fires occur. If that, and I'm not saying that's the case this time, but Vice Chair, any comments?
I'm ready to make a motion.
Please.
Mr. Chair, I move that for 2023, do a letter of education, for 2024, a $10 fine, and for 2025, $0 in the case of Jamie Adelberger.
Thank you. Executive, is that acceptable? Thank you. Administrator, will please call the roll. Item 32.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Item 3.3, executive.
Yes, John Hanlon, he had 2 prior violations, previously received a letter of education in 2019, and then incurred penalties in 2024, which he paid. This time he incurred penalties of $560 for filing his 25 SEI late. So it's his 3rd violation. The recommendation in your meeting books is to reduce it to $140. To explain his issues, he did point out that he was diagnosed with cancer or probable cancer, and he has in March and has been trying to manage doctors and specialists.
Comments, colleagues? Vice Chair, you ready for a motion?
Yeah. Mr. Chair, I move that we accept the recommendation of $140 in the case of John Hanlon.
Administrator will call the roll, please. Item 3.3.
Commissioner McCauley,
Aye.
Commissioner Thompson.
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Thank you, colleagues. Item 3.4, executive, please.
This is the city administrator for the city of Shady Cove. He had 1 prior violation in 2021, incurred $20 in penalties in 25. As a 2nd violation, the recommendation is to reduce the penalty from $20 to $10.
Thank you. Administrator will call the roll. Pardon me, Vice Chair will make a motion on 34, please.
Mr. Chair, I move we accept the recommendation of $10 in the case of Michelle Perry.
And now the administrator will call the roll. Item 3.4.
Commissioner Thompson.
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
You, item 35, executive, please.
Carl Smith, he had one prior violation that was paid. Current penalties were $150. Per the table that I read to you earlier, the recommendation is to reduce the penalty to $15.
Vice Chair, please.
Mr. Chair, I move we accept the recommended fine of $15 in the case of Carl Smith.
Administrator will call the roll. Item 35.
Commissioner Thompson?
Aye.
Commissioner Resendez Gutierrez?
Aye.
Commissioner Jancy?
Aye.
Commissioner McCauley?
Aye.
Chair Fiscom?
Aye.
Motion passed 5-0.
Forging ahead, colleagues, item 36, executive, please.
In Woodley, had no prior violations, but did file 23, 24, and 25 SEIs late, usually only by a day or two. So the recommendation is for the 23 SEI as a first violation, a letter of education, and for the 24 and 25 SEIs, that they, the 24 be reduced to $10 and the 25 remain at $10.
Thank you. Vice Chair, please, item 36.
Mr. Chair, I move that we accept the recommendation of a letter of education for 2023 for a $10 fine in 2024 and a $10 fine for 2025 in the case of Maureen Woodley.
Administrator will call the roll, please, item 36.
Commissioner Resendez Gutierrez?
Aye.
Commissioner Jancy?
Aye.
Commissioner McCauley?
Aye.
Commissioner Thompson?
Aye.
Chair Fiscom?
Aye.
Motion passed 5-0.
You colleagues, here's what we're going to do on items 37 through 62. We have a relatively new procedure to consider these STIPs unblocked. Before I ask the normal question on a consent calendar issue, I'm going to say that we're going to pull off items 53 and 56 and hear a comment from Commissioner Thompson in a moment. For that, however, with regard to these items 37 through 62, is there anybody else who needs to recommend pulling off an item? Commissioner Resendez Gutierrez, please.
Thank you, Chair. I don't have a recommendation to pull off an item, but I have to disclose a potential conflict of interest regarding item number 37 regarding Mark Simonson, Clatsop County School District number 30, Warrington Hammond. And the potential conflict is that my firm represents that school district, and so I will be recusing myself from participation in that item.
Commissioner Resendez Gutierrez, in order for you to recuse yourself from the vote, it would be either we pull it and consider it separately, or you would have to recuse yourself from voting on any of them. Given
Understood.
that the,
We should pull that item off,
you
I
would,
think, because we're down to 5 votes maybe.
We're currently sitting at 5 commissioners in the meeting.
right, and so with a potential conflict of interest, once you make your declaration, pull it and consider it separately, but once you make your declaration, you can, and we need you to continue to vote, otherwise we can't.
That's
Yeah.
fine. Then yeah, then I recommend that we pull number 37 due to my potential conflict of interest so that y'all can consider it separately.
Can I ask?
Let's talk about the issue relative. First, I'll make your comment, Commissioner.
Yeah, for numbers 53 and 56, I don't have a statutory conflict. I just have a personal and professional relationship with both individuals. For the sake of a quorum, I think I could still vote and not be,
That is correct.
I've declared, I don't have a statutory conflict. I've declared that I know these folks, but I would plan on voting because we have a quorum.
Yes.
We need it for a quorum. Okay.
Is that fair, Executive Council? I presume that is a fair approach.
If there's no statutory conflict, there's nothing to disclose technically. So.
Thank you. That's exactly the comment I was looking for. I appreciate you making it. Okay, colleagues, let's consider items 38 through 62 on block. with the removal of 53 and 56 to be voted on separately. Is that right?
And removal of
And
37.
Removal 37, 53, 56 will be voted on separately for purposes of this process. Otherwise, we will now accept a motion for the consent calendar approval of items 38 through 62 with the exceptions I noted. Vice Chair, please.
Mr. Chair, I move the commission approve the proposed stipulated final orders presented on the consent calendar as the final orders in those cases, and the chairperson be authorized to sign them as such.
For the motion, any comments, colleagues? The administrator will call the roll, please, on the consent calendar, items 38 through 62, with the exception of 3 noted, 37, 53, 56. Please proceed.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson.
Aye.
Chair Fiscum.
Aye.
Motion passed 5-0.
We'll now consider item 37. Commissioner Gutierrez has already announced, made the announcement, the declaration here. That declaration stands. The vice chair will make a motion, please.
Mr. Chair, I move the commission approve the proposed stipulated final order in agenda item 37, Mark Simonson. And this matter, or let me start over again. In the agenda item 24428, in the case of Mark Simonson, I move the commission approve the stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Thank you, Vice Chair. The administrator will call the roll. Item 37, please.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Sorry, for some reason I got it confused. Is this 37?
It's 37, yes, sir.
Well, right. So then I'm recusing. I abstain.
Okay, so Commissioner Resendez Gutierrez, you have announced a potential conflict of interest, which under the law allows you to vote on the matter once you made the announcement. And absent your vote, we do not have quorum.
Right. Sorry about that. Then I'm an aye.
Thank you. Thank
Chair
you,
Fiscum.
Commissioner. Please proceed.
Yeah, Chair Fiscum.
Oh, aye. I thought I said chair. I thought I said Mason, but that's fine. I'm here. Aye.
Motion passed 5-0.
Thank you, Commissioner Gutierrez, for your sensitivity. We appreciate it. We'll now move to item 53. The declaration has been made previously by Commissioner Thompson. Vice Chair, please proceed.
In case 25045, Kathy Clark, I move the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
You've heard the motion. The administrator will call the roll. Item 53.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Chair Fiscum.
Aye.
Motion passed 5-0.
Item 56, Commissioner Thompson's declaration stands as given. Vice Chair, please.
Case number 25049, Danielle Bethel. I move that the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Administrator will call the roll, please. Item 56.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Chair Fiscum.
Aye.
Motion passed 5-0.
Okay, colleagues, let me just pause for a second and ask our executive if we have any indication that folks involved in item 64 are here or not.
They may have arrived. Do you want to take care of the other stip?
Yeah, we got
Happy to do so.
63.
And then maybe
Super.
take a bio break and
Thank you for that suggestion. We will proceed in that direction. Item 63, involving Miss Stephanie Simmons. Was she scheduled to appear, investigator? I think the answer is no. The process calls for a report by our investigator. Investigator Pacheco, please.
Thank you, Chair Fiscom and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 63 in your meeting book is a stipulated final order for Stephanie Simmons, former program specialist for the Multnomah County Stability Initiative. On April 28, 2023, the commission voted to move this matter to investigation to determine if Ms. Simmons had violated the provisions in ORS Chapter 244. In the preliminary review report, it appeared Ms. Simmons had failed to declare a conflict of interest and used her position when she contacted office staff on the status of her brother's rent assistance application and the timeline for her as her brother's landlord to receive rental payments. During the investigation phase, commission staff were able to verify Ms. Simmons' violation of ORS 244.0 sub 1 and 244.120 sub 1 sub C. Ms. Simmons has agreed and indicated that she wishes to conclude this matter and has signed the stipulated final order. The order in your meeting book provides that Ms. Simmons will pay a civil penalty in the amount of $500. We are recommending that the commission approve the stipulated final order. Thank you.
Investigator, any questions for our investigator? Hearing and seeing none. Vice Chair, please. Item 6.3.
Mr. Chair, case 23029, Stephanie Simmons. I move the commission approve the proposed stipulated final order as the final order in this matter and the chairperson be authorized to sign it as such.
You've heard the motion. Administrator will call the roll, please. Item 6.3.
Sorry, mute on me. Commissioner
No
Jancy,
problem.
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscom.
Aye.
Motion passed 5-0.
Okay, colleagues, there are no default final orders, so we'll now move to the reports of investigation, and we'll have a bio break to decide if folks are here to present to us relative to item 64. We're now in recess.
Fiscom likes his gavel.
He told me to pound it. Sit in as many chairs at the table as you choose, folks, and we'll proceed in just a moment officially. And you can introduce yourself for the record in a few moments, not right now. Thank you for being here. Let me know, executive. Let them gather and
We're doing our administrative overview. Can we do something about, can't take vacation anymore?
that's a good idea.
You too.
Yeah, where's Becky?
Yeah.
We can't run a meeting without
Is
Becky.
Fiscom gonna do anything online?
That's a good question. No, I can't
Exactly.
and won't. Oh, fire me.
By the end of the year.
You're right.
By the end of the year.
Got it here. Are you ready, executive? You tell me. I will.
You have an extra. You do?
It's organizing them for each person.
So while they're getting ready, I will let the commissioners know they are planning to refer to exhibits. And given that the commissioners, many of them are online, they just emailed the exhibits that they're going to refer to me, and I have forwarded them to all of you by email, and they will provide the two of you with copies.
Thank you. When you're ready, Ms. Hoffman and others, will proceed.
Great.
You just let me know.
I think we'll wait in 1 second while
That's fine.
Ms. Birch pulls together.
I think we have the two copies. The exhibits we may be referring to that are not included in the exhibits that we previously submitted.
We're ready. Oh, you know what? I think it would be good if I turned off my,
That's a good idea. Like I did mine.
it's always bad when one's child calls and you go, should I answer it here?
Depends on the reason for the call, pardon me, but that's, I understand. Okay, this is a reconvening of the Oregon Government Ethics Commission public session on July 11th, 2025. We are gathered to proceed through the rest of our public session agenda on this day, Friday morning, July 11th. Our approach on the item before us by number 64, better number 23-071, dealing with Mr. Boba Subasic, is to hear first a report from our investigator. In this case, it will be our executive, Susan Myers, after which we may have questions for her. And then we will allow our respondents time to make comments to us, and that can include councils and or the individual name, Mr. Subasic. And then we may have questions for you. And eventually we will move toward a commission decision. As our executive has said, there are 2 commissioners in the room today. There are several commissioners online who have been hearing issues all morning with an ability to hear. So they will hear your comments as well. And as our executive said, the documents you have for us today have been sent to them in the last moments. All of that said, let's proceed with this item number 23-071. Executive, please.
Thank you, Chair Fiscom, commissioners. This is the Executive Director, Susan Myers, for the record. So agenda item 64 is an investigative report for the case involving Boba Subasic. Boba Subasic is the former Chief Information Officer for the Oregon Liquor and Cannabis Commission, which I will abbreviate to OLCC. As the commission is aware, this was one of 6 cases involving OLCC employees getting access to bottles of rare bourbons, specifically Pappy Van Winkle and Elmer T. Lee. As the report in your meeting books indicates, the available information is that Bobasu Basic began with OLCC in 2018, which is about the same time that the Chance to Purchase lottery began. The bottles at issue are when the OLCC put bottles in the lottery, it would keep more of those bottles separate in the safety stock. That is because if someone were to win and the bottle were to break in transit or otherwise, the OLCC would still want to provide them a bottle. So when they instituted the Chance to Purchase lottery, they began saving more of these specific bottles in their safety stock. Once those bottles in the lottery got distributed to the winners, then OLCC would communicate internally that we can now release the bottles in the safety stock, and those bottles would be taken out of basically hiding. And they were hiding in 2 different ways. Hiding in the warehouse, they're not in the regular stock, and hiding in the database system, they're not visible as something anyone can order or ask to be allocated. So once all the bottles in the lottery got allocated, they can release the safety stock, meaning put it into the OLA system so that a liquor store or anyone else could look it up and say, oh, I want a bottle of this, please send it to my store. And then also move it from the secret location in the warehouse to the actual stock in the warehouse. The information in this case indicates that what was happening at the OLCC was that the OLCC employees cannot participate in the lottery. They were certain employees, including Mr. Subasic, were contacting the warehouse manager once the lottery took place and having bottles from the safety stock sent to the liquor store for them to purchase. And that was prior to any of those bottles being uploaded into OLAS as being available to the public or liquor stores. And therefore, that was confidential information that those bottles even existed and could be allocated. In this case, in his interview with Travis Hampton, Mr. Subasic indicated that over the course of his tenure, the relevant period, that he had purchased 4 to 5 bottles of either Elmer T. Lee or Pappy Van Winkle. He and everyone else involved in this matter did pay the actual list price for the bottles they obtained. The report explains and recommends that there was the use of confidential information, which would be a violation of 244.040 sub 4, because the public did not have access to the information on the availability of these bottles. There was the use of position in 244.040 sub 1. That provision says that a public official may not use or attempt to use their position to obtain a financial gain or avoid a financial detriment. In this case, the financial detriment is that at the time of obtaining these bottles, it isn't as if anyone can just go to a liquor store and buy a bottle of Pappy Van Winkle. It is extraordinarily rare, and everyone wants it, it is vendor allocated. So once it arrives once a year, it gets allocated in accordance with what Buffalo Trace says to who Buffalo Trace says it goes to. And primarily that is, it goes to specific liquor stores who then sell it to bars and restaurants and preferred purchasers. So this is an alcohol that is not readily available to members of the public. In order to purchase Pappy Van Winkle on demand, like I want to go buy a bottle right now, I can go into Ola's and look it up and it will tell me there are no bottles available. I can't. Buffalo Trace and OLCC's system doesn't allow me to go in and ask OLCC, well, could you order me a bottle from Buffalo Trace? That's not how they operate. So my options at that point would be to try to find a bottle somewhere. Against the law to ship into Oregon. I would have to go to another state where I could purchase a bottle and bring it back with me, which would be a financial detriment. So by using his position to gain access to these bottles that were not yet in any way made available to the public, our contention is that Boba Basic violated 244.040 and avoided a financial detriment of having to pay the costs that would be necessary to purchase the bottle in any other way. And then finally, the recommendation is also a violation of ORS 244.120, which is conflicts of interest. That at the time that Boba Basic requested a bottle in his official capacity, using his access to the warehouse manager and his access to the information that these bottles existed, that he would have a conflict of interest requiring a written disclosure to his appointing authority. It is our understanding no such conflict of interest disclosure was made in any of the 4 to 5 bottles that Mr. Sapasic purchased. The recommendation in your meeting book is to make preliminary findings of violation of the 3 statutes and move the case to a contested case hearing process.
Executive, colleagues, so now's the time for any questions of our executive that can be based on her report, just given orally, as well as a document in your file. Looking to see if there are any questions that commissioners would like to ask our executive. Hearing and seeing none for the moment, we'll now turn to our, use the one word, respondents. Mr. Sapasic and your counsels, this is your time to make any comments you choose to make to us. Welcome to Salem this morning. You may proceed in any order you choose to make comments to us, and please, as you make comments to us, identify yourself for the record. Thank you for being here this morning.
Thank you very much. This is Janet Hoffman on behalf of Mr. Sapasic and my co-counsel Rachel Birch.
Good morning.
Mr. Sapasic will not be addressing this group. However, he did prepare a letter in advance, and I believe that was submitted to everyone.
It was distributed online to all of us, and we had the freedom to make copies, and most of us did so. You have another copy this morning, which we appreciate. So that is on the record. Thank you.
Perfect. Now, the other thing is I'd like to make sure, because looking at the volumes of material, which I have 2 full binders, I printed what I believe is before you either electronically or in printed form. There's a great deal of material here. And within that, Ms. Myers, we're grateful for it. You copied the February letter we presented, but I want to make sure that everyone got the letter and realized that they weren't duplicates in June. So you have in front of you two letters, so I just want to make sure you got both. Because the first one was prepared before we received some additional materials from Ms. Myers. And it addresses those additional, the second one does, and it addresses those facts. So really the letter that got presented to you has been supplemented and really replaced by the one that we submitted in June.
Executive, all those documents are in fact on the record, is that right? And
Yes, all of the documents are on the record, and the more recent letter dated June 30th was provided to them with the copy of the report as the meeting material.
Good, because as I was looking at it, I wasn't sure that that was made clear from the record. So we're here for a very serious reason. As far as Mr. Sabasic's life, this is probably one of the most important days that he is appearing for, because we're asking you to find that there is not preponderance of the evidence to push this case forward to a contested hearing. And we realize, in light of the fact that you have already approved stipulations, you've already asked people, why are these stipulations even appropriate? We're not the first people that have come before you. It's hard to start fresh and say, Mr. Sabasic is his own person with his own set of circumstances. And the amount of work that we've done, as you can tell by the submission that we provided to you, is vast. And so what we're asking for today requires sifting through a lot of information. What I think the most effective way to use our time without rereading to you a letter that you've all had the opportunity to review is to more talk about this matter, both within the body of law that this complaint takes place in, and then apply the facts to the law, and then deconstruct basically what we believe to be the pillars of this recommendation, that it is our position are based on speculation and on inferences that are not supported by the record sufficiently to come to a conclusion that there is a preponderance of the evidence. So first of all, what we know by Court of Appeals opinions, by statutes and the like, is that we know that there's definitions of pecuniary gain or having a financial incentive for oneself or one's relatives. We understand the concept that acting in one's official duties is different from a person who is a state official acting in their individual capacity. And we also know by case law and statutory pronouncements that there is a highly defined concept of what is public versus confidential information. And I would like to address those because it's our position that the facts in this record do not support the finding by you that there is a preponderance of the evidence regarding those issues. So the first thing that I'd like to talk about is I'd like to just address right now the concept of financial gain. Under the case law, and we've laid it out in our pleadings, the general standard for determining financial gain or loss is a basic fair market principle. It's what is a willing buyer and a willing seller, what are they prepared to buy and sell it for? And a basic review of what is the market within the jurisdiction that we're talking about. Under this case, Mr. Sabasic paid for these bottles the exact same price as any citizen in the state of Oregon, any resident in the state of Oregon, anyone who is qualified to purchase one of the bottles. We also know from opinions in the state Supreme Court and appellate court that we've cited that your opinion that you render must be supported not by conjecture, speculation, and surmise, but by real evidence. So before you come forward with a preponderance finding, it cannot be a speculative hypothetical. The concept that Mr. Sabasic would travel to Nebraska to purchase a bottle of Pappy Van Winkle's or Teal's or whatever, any of these restricted products, is an unsupported concept. There is no evidence that he was prepared to buy an airplane ticket. There is no evidence that he can travel to Nebraska without the assistance of his wife, who happens to be sitting right behind me here. There's no evidence that he'd want to pay the thousands of dollars that it would cost for the two of them to fly to Nebraska to go buy some restricted bottle of alcohol. If ever there was a heartland of speculation or conjecture, that is a heartland of that. To even throw up the idea that he would go to Nebraska and was saving the money to go to Nebraska to purchase one of these bottles. So in two of the claims against him, a core concept is this financial gain, that he obtained a financial gain by purchasing or taking advantage of confidential information to get an opportunity to purchase that, but for his position as a public official, he never would have had. There is no financial gain, and there was nothing in this case where he was offered a financial gain. He was offered at fair market value to purchase a bottle of hard to get bourbon. And he purchased it, just like any other person. Another conjecture in this case that we have to dismantle is that he gained any information whatsoever during a time when these products were in their embargoed bailment status. If you pour through the record in this case, what DOJ gave the Ethics Commission and what they relied on and what your advisor found, there is no evidence whatsoever of information being obtained when this product was kept secret. The only time these products, any evidence is developed about these products by witnesses who are interviewed by DOJ or as part of the employment process that you have those interviews for, develops a storyline where a lottery occurs. Now there are this reserve stock. The reserve stock now, something is going to be done with. It is going to be either sent directly to liquor stores. It could be sent to favored customers of liquor stores. It could be sent to clients or customers of vendors. It could be sold to OLCC employees. So the question is, once they know what their extra stock is, that is when the decisions are made, who gets a chance to purchase. So it is not secret embargoed information when that decision is being made. Several things happen. When that stock is returned to general stock and this decision is being made, the liquor stores have access to it. And they are not embargoed to keep that information secret. Once it's up online and the liquor stores have access to it, they can call their favorite clients. They can call the whiskey shop in Portland, Oregon, the Whiskey Club. They can tell them there's some extra bottles. They are free to spread this to the wind. They can call an Oregonian and announce what's available. It is not secret information. And that step has been jumped over in calling this protected secret information. The DOJ, the Department of Justice, determined in their report they couldn't prove this was secret information. And they interviewed 40 people. They brought online emails. They looked through email searches. And the reason it can't be deemed to be a secret is because people had access to it and could do whatever they wanted with it. And under the case law, once information is released or available for release to the public, it is no longer secret. So when the liquor stores could go online, tell their clients, once vendors are called, because the vendors are called, when you read these records, one of the activities that Ms. Leslie does is she lets the vendors know themselves, the manufacturers or the wholesalers, we've got extra bottles here. We're not going to be using them in our right to purchase program. Do you have a direction for them? It's public then. The moment they tell the vendors aren't secret holders. So under case law, this information is no longer secret. So Mr. Sabasic is not receiving secret information when he is advised that these bottles are available. That is the other pillar that you must show, that he is on the inside of information not available to the public. That pillar is gone. There is a conflict in testimony between Ms. Leslie and Ms. Leslie. You have an electronic interview of her that I'm afraid was never transcribed by anyone in your database. But when she is first interviewed about how these bottles are offered within the OLCC for purchase, she says she called people and she told people. She later says, once she's been told she's a subject or it could be criminally involved, she now says they called her. You have two different stories by the same witness that your advisor is asking you to adopt, that they called her. That is a fact in dispute. What happened? It is not a fact. It is one interpretation of two facts that one witness told. Another key thing that has to be talked about was an opportunity taken by Mr. Sabasic that belonged to someone else that he took in his official capacity and was only able to obtain through his official capacity. And the answer to that is no. The legislature, in their wisdom, enacted a statute that said that employees of the OLCC are entitled to obtain bottles of alcohol sold by the OLCC the same as any other citizen in the state. And I keep throwing in the word citizen, but please take it as person in the state. He is entitled to buy one of those bottles in his official capacity. He's not using secret information. He's not paying a below market price for that item. And the information is public at the time that he buys it. The information is even more public because once the information is put online by the liquor store, which happens when the bottle is sent in transit by the OLCC to the liquor store before it's handed over to Mr. Sabasic or any other employee at the OLCC, they unload it on their public terminal. So any human being who wants to buy one of those bottles can go online and see where those bottles are. And that is before he picks it up. So you could say to yourselves, well, that doesn't help him. It's already been promised to Mr. Marks, or it's already been promised to Mr. Sabasic. Well, the truth of the matter is the system doesn't work the way the system's supposed to work. It's quite often a first come, first serve. You will see in our Exhibit L a spreadsheet that extends back from the time of the initiation of the right to purchase that shows where these bottles actually went. And what you will see is, despite the fact that many bottles have been committed for the right to purchase program, like 900 or so have gone to people who weren't part of any of these programs. And you'll see the notation NUL on the column, and you divide it by 3, and that's how many bottles. So to say that just because a bottle is put aside by Mr. Sabasic at the request of Ms. Leslie, that he's actually going to get the bottle, requires a couple of things. It requires that the liquor store comply. They're not obligated to comply. That isn't part of their contract. If they want to do a favor for the OLCC, they can do it. But if a more favored customer comes in and says, hey, you promised me that bottle, there's nothing to stop the liquor store from giving it. It is not a restricted thing. There is a favor request from Ms. Leslie to set aside the bottle. And you will see that part of the reason why they have a reserve stock in the first place is quite often those bottles are sold to other people and they're not even available for the reserve stock. So they have to bring them out of the reserve stock to make them available for the people who win the chance to purchase. So it is not a guarantee, and it is open to the public. So that is just an important thing for you to understand, because what has happened here is a package of information has been put together, but not put together by people who have the incentive or the responsibility. This is not a blame. This is not anything against Ms. Myers or anyone who works for the commission. That's why you allow us to come. We have an incentive that is different than the incentive of the people who just review cases to spend hundreds of hours going through these and looking for exhibits and finding these facts. Your system breaks down if you also ask your people to do the defense. So that is why we're so grateful to have this opportunity to be here, because this is the way the system should work. Someone who has an incentive to know the documents needs to come before you and say, stop, you've got to take a look at this. This is why Mr. Sabasic didn't settle a case for $500, because his ethics told him he needed to come to you and say, this isn't fair. And that make you please understand there are more facts in this record, more things that you should know. We have an Exhibit C that we copied for you, and I think they're online, and it's a problem because it's hard to go online and take down electronic documents if you don't know what to look for. But you will see in Exhibit C, we just compiled some proof, 100% proof, cannot be disregarded, that Ms. Leslie was doing the same thing for the public that she was doing for Mr. Sabasic and the members of the OLCC. She was looking for bottles of restricted alcohol after they were released from embargo and seeing if she could locate them and help them find them. And you get thank you notes that are sent to her and Mr. Fleming's from just Joe Citizen out there who called the OLCC and said, I can't find these bottles. Can you find them for me? And what you'll see is that the OLCC took time and found these bottles for them and even got thank you notes. So the same service that Ms. Leslie was offering to people at the OLCC, she was simultaneously offering to the public. And you will see a selection of these that we found. A priest through a colleague found numerous bottles, and the person who tried to get them for him writes this thank you note and says, hey, by the way, will you get 6 others? Another family said, we really didn't think you'd help us at all. And they said, thank you so much for doing it. We're amazed. We got these bottles. And so you will see that this is not just a spin. This is a fact documented. And it was another thing that really strongly influenced the state when they declined this as a prosecution, because they couldn't say that this was a limited opportunity that was just offered to employees from the OLCC. It was an opportunity that was offered by the OLCC to the public as well. The next thing that I want to cover, because I realize I've taken quite a bit of your time and I'd like to be able to answer your questions, is there was an argument made by us, and we still maintain this argument, that this commission has not proved whatsoever that anything took place within the statute of limitations. And we stand by that. First of all, the commission relies on 2 emails, and I'd like to point them to your attention.
They were included as our original Exhibit N.
So they're Exhibit N1 and N2. And the packet that you got referred to these emails. And what they are is, one of them is and as you all know, you have to have evidence presented to you by your support staff that you can rely on to a preponderance of the evidence that you can prove that these bottles were purchased between 2019 and 2023, a 4-year period. So an argument is made in the commission package that you received that these prove that Mr. Sabasic purchased bottles within that time period. And so I'd like to read from you the first one. The first one is from Mr. Nakamisha to Chris Mayton, dated December 18th, 2020. It says, ordered. Boba had to sign for it since I purchased it, just a heads up. There is no tagline, there's no subject line to this. It is just a straight up email. There is nothing that you have been told that any part of this scheme required anyone to sign for it, nor is there any evidence that this was purchased from him by Mr. Mayton, but that isn't the point that I'm raising here. I'll get to the point I'm raising in a minute, but on the face of the document, it is not related to this offense. I now want you to go to number 2, and it's from Boba to Laura Gomez, and he writes, just ordered both. These are used as the smoking gun that you are within the statute of limitations. We created an exhibit this morning for you, and I'm afraid I have buried mine in my pile of materials in my excitement, but it is the document that describes Mr. Sabasic's job. Mr. Sabasic was the head of technology. One of his jobs is orders and procurements for the OLCC for products that are used in the technology of running the OLCC. Mr. Sabasic has to approve all those orders. Within that context, Boba had to sign for it since I purchased it, just a heads up, and Boba's saying just ordered both. Part of his ordinary job, approving the order that goes along with his job description. To claim that those are documents that he had ordered alcohol that was somehow or alcohol ordered within this time frame would be an abrogation of what the State Court of Appeals and Supreme Court have instructed this commission's duty to be. You cannot engage in speculation. The other thing, Ms. Leslie is quoted as being a support for the position that these items were ordered during a specific time period. What she says is she could not recall exact requests of frequency. And then this is the investigator Hampton describing the interview. When I tried to detail this aspect, Leslie advised her memory was poor on these specifics, only estimating the number of years, this is all estimating, respective employees have made this request. Again, the Department of Justice, when they explained their declination for this case, cite that they cannot find evidence that any of the purchases in this case took place within the statute of limitations. So then you go to Mr. Sabasic's interview, because you have access to Mr. Sabasic's interview, which Department of Justice didn't have. So I want to be clear that you have more data than they do. And he says, when he's interviewed, that he doesn't remember when it was. So he says, so if you have done this 2 or 3 times, do you know how many bottles this might involve? And he says, total 4 or 5. Can you guess how many years this? And he's asked to guess. He's not asked, do you know? He's asked to guess. In a court of law, which I understand this isn't, you would never allow someone to guess and call that evidence. That's speculation and conjecture. He says, well, pretty much when I started, so 4 years ago or so, or maybe every other year or something like that. He's guessing. You don't have evidence that equals the preponderance that this took place within a statute of limitations. So I believe that one final thing that I want to deal with, that although it's a technicality perhaps, there is an allegation here that Mr. Subasic, acting in his official capacity, failed to get a clearing of a conflict of interest. I think that that's number 2 or it's number 3, I believe. First of all, there is a limitation to what is acting in your official capacity legally and under the guidelines that you operate under. Mr. Subasic does not contest that he is a public official. But what the record shows is that he purchased those bottles in his private capacity. The citation to doing an act in your public capacity applies to, for example, a city commissioner who's voting on a housing development. And that housing development, maybe he owns the property that's about to be developed. That would be a potential direct conflict of interest. So under those circumstances, that commissioner, since he would get a pecuniary benefit if the zoning is changed to allow development in his property, would not vote on that and would recuse themselves, or they would seek a higher up to get a clearance. That is when that provision is used, when they're in their public capacity. Mr. Subasic, but let's assume that I'm wrong about that and I've misread the law or I don't understand the statute. Regardless, Mr. Subasic's person that he would clear the conflict with was working under the same understanding and the same principles that Mr. Subasic was working under. He himself was ordering bottles. And it was recognized that this practice had been going on for 30 years. So whoever he would have sought clearance from, this was not recognized to be an issue. So we raised the point in our pleadings that it would be futility to write that letter. But the point is, legally, he was not acting in his official capacity when he obtained the bottle that he obtained. I think I've covered for you the high points of why I believe that when you listen to the report and read the report that you had in front of you from your department, from your commission, and why, even though other people chose to stipulate, it doesn't mean that there was, in fact, ethics violations. And part of the problem that all these people have been under, and it's not my job to argue for them, but Mr. Subasic still is somewhat constrained, and why I said I'm the one who's going to do the answering today. The Department of Justice has still said that if they can develop more evidence, they may relook at their case and go after them again. But it's the evidence they have, which is, we feel all these records, they had to decline. So please ask me any questions, because I realize that I've come in with a lot of information and we've provided to you when there used to be phone books, it would be the New York phone book worth of documents. And part of the problem is they're electronic, they're online, they haven't been transcribed. We do have for you, if you want to hear Ms. Leslie's statement, we can play it for you. We transcribed it, and that's one of your exhibits. The problem is she speaks with a very strong accent. And even when we transcribed it, it isn't crisp in a way. So we have a transcript. We're more than glad to play it for you if you'd like to hear it with the transcript. We also are glad to bring up any exhibits that you haven't had a chance to look at and explain them if you want to see them. We'd like to do anything that we can to help you understand this voluminous record.
Thank you, Ms. Hoffman. Before we proceed in any direction, I want to make sure that Ms. Birch doesn't have any comments to make right now, and I'm presuming the answer is no, but your choice.
Dan has stolen my thunder. I think.
But just the basic, I understand you don't want to speak today, but I want to give you that chance. If you do want to speak to us in any way, it's your prerogative to do so, and this is your chance if you want to say anything.
Wish I could. That's a lot I could say, but that's why I try to get this written statement to you all guys.
Fair enough. That did arrive.
There are circumstances that I have to follow my.
Appreciate that. That derived at our transit. No pressure from me, just an opportunity, and thank you for being here with your wife today. We appreciate that. Okay, colleagues, now is the time for us, the commission, to ask any questions of Ms. Hoffman or others who are in the room from, quote, the respondent standpoint, unquote. Are there any questions? Now's the time.
I have a couple of.
I understand Commissioner Thompson will wait, Acting Vice Chair Thompson will wait to see if others have their hands up, in case they do, those commissioners online who have listened to all this. Okay, Commissioner Thompson, please.
Thank you, Mr. Chair. Thank you, Ms. Hoffman, for being here. I really appreciate all of you coming down and going through that detail. I have two questions. Much to my wife's chagrin, I am familiar with the Oregon Liquor Information System and how to look things up. So she wishes I wasn't, but I am. And there's no warehouse stock listed on there that I can recall. So when the warehouse stock, I mean, I, as a member of the public, can't see what's in the OLCC warehouse. And my follow-up to that is there's nothing on there that says, if you see something you want, email this Miss Leslie and she'll get it for you. So I'm still hung up on the fact that I, as a member of the public, don't necessarily have the same access that people working at the OLCC had. Am I missing something there?
You're not missing something. I can explain. The warehouse stock is available to the liquor stores.
Which are OLCC agents.
Agents, and they can distribute the information. Okay. The way that you as a member of the public can know what they have available is to call someone and ask. But I'll now ask Ms. Birch, who is really the document maven and studied this, answer you.
So there were, like Janet said, two different systems. There was one that was the warehouse system that was available to liquor store agents, and the DOJ found that they could distribute that information how they chose. The other piece was that before any of these bottles were able to be sold, they had to be uploaded into the OLAS. So they were uploaded into that public system prior to any purchases being made. And in addition, there's just that Exhibit C, which is the members of the public who are particularly fond of a certain type of bottle and will reach out to the OLCC and ask for that. And then that service was provided to them. So it's not that they necessarily had, they knew they had it in stock, but when it was in stock, they were informed of that.
Just for the record, the last person who commented in response to a question was Ms. Rachel Birch from the Hoffman Law Firm.
Yes.
Right. No apology necessary. I just want to make sure that our record is clear as to who was speaking. So thank you for making your comment, your question. Other questions?
Yeah, one more question. I'm not an attorney, so forgive me if you can't answer this question for legal reasons, but if the issue is that there's no evidence that he purchased it during the period that is this, the period that we can review as a commission, why not just make that, just say, hey, he didn't purchase any bottles? I mean, why do we have to go through all of this if he didn't purchase any bottles during that time? I'm just curious why that's just not the defense.
It's part of it.
No, the reason why, and I guess I'm kind of a stickler for these things. When the government has a burden or your commission has a burden and you can't satisfy a burden, as a citizen, we're entitled to have the evidence presented against us. And I take that very seriously. So if you have a preponderance, or in criminal cases I try, the government has a duty to prove, I really think it stops there. It isn't our job to fill in what you don't have. I'm sorry about that.
No, I'm not asking you to tell us when the bottles were purchased. I'm just curious why the entire defense is we didn't buy any bottles during your jurisdiction, so we're not.
Because number one, that does require us to come forward and prove a point.
Okay.
It shifts the burden on us.
Gotcha. Okay. Thank you.
Something to that as well. This is Rachel Birch. There is that statute of limitations defense, and that's definitely part of this, but this is there's so much more depth to this case that we thought it was important to address all of these different defenses. The fact that there's no proof of pecuniary gain, the lack of confidential information. So though theoretically, yes, you can throw it away on a statute of limitations issue, it was important to us and to our client that the whole story was told.
Thank you, Mr. Chair.
To be honest, we'd rather be exonerated completely.
Yeah.
Fair enough. That's a fair answer.
We sense that. Thank you for
That's a
your
fair
time.
answer.
Executive, I want to give you a chance to comment in some general way about what you've heard from the respondents today. And I've got a couple of questions, but let me start with the general. This is a chance I want to give you to respond in any way you choose to what you've heard and what we've heard. Thank you.
So specifically addressing the jurisdictional period question.
Yes.
So in his interview, Mr. Subasic said that he had received 4 or 5 bottles. When asked how many years this was spread over, he replied, pretty much when I started, which would have been in 2018, prior to the period of our jurisdiction. So maybe every other year, there was no specific timing. It was when I would hear about it. We have in Mr. Maiden's interview, him saying that, yes, he picked up a bottle for boba last year. We have Ms. Leslie saying, so it was not saying that he had obtained these bottles within the time period. It was not as if we were relying solely on those 2 emails that they highlighted. There was repeated references to Mr. Subasic participating in this practice. Additionally, his receipt of 4 to 5 bottles, only one of the lotteries preceded our jurisdictional period. So under his theory, he would have received 4 or 5 bottles right after that first lottery and then never done this again in the jurisdictional period. So he took this theory would have him say he took these 4 or 5 bottles one time, not one or more times, as he said in his interview, and not, as Mr. Maiden and Ms. Leslie indicated in their interviews last year. So in my mind, there is a preponderance of evidence based, in fact, upon both his interview and the timing of when these lotteries took place in conjunction with when our jurisdictional period was, that he obtained the bottles with at least more than 1 bottles within our jurisdiction.
Thank you. Other comments, please
I do want to clarify one point. There is OLCC statutes and rules and processes do allow for something called reallocation. So if I, as a member of the public, really want a bottle of something, and I'm not finding it, I live in Monmouth, they have one liquor store, maybe two, probably just one. And I go to the liquor store, they don't have the bottle I'm looking for. I can call or go online to OLCC and say, okay, can you help me find this bottle? And OLCC will look in OLIS, see if it's available at another liquor store, and can ask that liquor store to reallocate it somewhere else. That is not what we are talking about. These bottles weren't in OLIS, had never been allocated to another liquor store to be reallocated. There's also a process where a member of the public can ask OLCC for a special order. That is not what this was. This was not OLCC helping a member of the public contact Buffalo Trace to make a special order for Pappy Van Winkle. These bottles are hidden away from both the inventory control system for the warehouse and from OLIS. The liquor stores do not yet know these bottles exist. And even members, Rich Evans, indicated people at OLCC, other than those who were in on the system, did not know these bottles existed or could be ordered. So it's not the same as those members of the public who are asking, can you help me find a bottle of Plantain or whatever? It is bottles that are hidden away until they are released. And the question would be that if Mr. Subasic and other OLCC employees were gaining access to those before they were released, before they were added to the system as bottles available to be shipped somewhere, that would be the use of confidential information for personal gain.
Thank you. Further? Colleagues, any other comments, questions? I've got one comment I'll make in a minute, or a question, maybe both. Looking for others to make a comment. Colleagues on the line.
Chair Fiscom, Commissioner Jancy here. Could I ask a question of Ms. Hoffman?
Oh, please, I was looking for your hand, Commissioner Jancy, but please, thank you for getting my attention. Please proceed.
Thank you. Ms. Hoffman, thanks for being here. I just wanted to clarify your position regarding pecuniary gain.
Yes.
It seemed to me that the case that you cited in your letter, Carrigal, was dealing with a situation where there was no evidence of any receipt of anything tangible, which seemed pretty distinguishable from the case here. Here we know that Mr. Subasic did receive the bottles, and the question on pecuniary gain seems to be, how do we determine replacement value? Do you have some authority for your position that the commission would need to make a finding that he would in fact travel to actually make such a replacement? It seems to me in most cases involving replacement value, evidence of market value and other evidence such as what's in the record here is entirely competent to allow a body to decide on the pecuniary value.
Ms. Hoffman, please.
Sure. I think that perhaps we're at cross purposes because Mr. Subasic actually paid something, and the amount that he paid was the list price. And so what he received in return for his payment of the list price was a bottle. So he received nothing greater in value than what he paid for. He didn't receive anything less in value than what he paid for. And there wasn't like a huge discount because of his position, nor was there a savings done to him. And that appears to be both under the case law and statutes, that's how you figure out gain or loss. You don't pick a hypothetical other jurisdiction. So the question really would be, if he had a right to buy that bottle in the first place, which our positioning is entitled, then the amount that he would pay for that bottle would need to be the same, not greater or less than is being charged to anyone else.
Mr. Jancy, please follow up. If you have a follow-up.
I don't have a follow-up, but I do have one other question, unrelated. Ms. Hoffman, I'm trying to understand, in your letter on page 4, there's a discussion about the OLCC employees adding the bottles to that have been, I guess, put on hold and are being ready to be picked up, entering that into the OLAS database. So is it your position that entering that information, as long as it happened before the pickup occurred, that would be sufficient public disclosure to negate the confidential requirement?
Yes, but also other aspects also negate it. Once it's put in the warehouse, the liquor stores themselves have access to that data, and they're not embargoed from sharing that to the world. The vendors themselves have access to what's left, so it's already been disclosed. And then the entry needs to be made upon receipt of the bottle by the liquor store. And so it's a conglomerate of information.
But the listing on the OLAS is the first point at which the average member of the public could pull that information up online. Is that right?
Up online, but if the member of the public called at the time that the material was now in an unembargoed state at the warehouse, that member of the public would, as you can see from our Exhibit Cs, would be helped by an OLCC person to see if it could be located.
That member of the public would not have any other way of knowing to make that call at that particular time. Isn't that right?
Well, no, they might, because they announce who won the lottery.
Could you expand on that?
Well, they advertise who the lottery winners, that the lottery occurred. So the lottery has now occurred. Once the lottery has occurred, it is going to build tally. Do they need, in satisfying people's orders, do they need to take bottles out of the reserve? So they now know how many bottles are left. Once they know how many bottles are left, that information is no longer private, and everybody can know it either through word of mouth because they know the lottery took place, and they can start calling the OLCC. Rachel Birch would also like to add to that.
Ms. Birch, please proceed. Commissioner Jancy, hang on 1 second, then I'll call back on you. Please.
There's also, when you're looking at the definition of confidential information under the OAR, it doesn't require that it be disclosed to all of the public. It simply requires that it no longer, or that it be voluntarily disclosed, or that it be disclosed through a public records disclosure order or a court order, which are areas in which more narrow, or the information would be given to a more narrow area of the populace as opposed to the entire public. So the simple disclosure to the vendors, to these liquor store agents, the ability for it to be shared, the ability for them to be called while it's in the warehouse, in then addition to the OLAS posting, is that kind of combination of it being voluntarily disclosed to the public under the OAR.
Could I also jump in?
Please.
Okay. There are two things, and I think to help you understand this under Exhibit C, you'll see the letter from the representative of the priest. They received product before anything is published one way or the other by their phone call. And you'll also see a restaurant also received in the timing materials. So this isn't like a special world of those who are somehow insiders know to call or know to find out. And people are willing to look through their inventory to provide these bottles to the public.
Mr. Jancy, please feel free to follow up if you have any follow-up.
No, appreciate the response.
Thank you. Other commissioners, any comments or questions? I think this is going to be in the form of a question for me. Ms. Hoffman, in your June 30th letter to us, early words are Mr. Sabasic's choice was to participate in a frequently and widely accepted practice, etc. I'm abridging, I'm taking a sample. And in your last paragraph, you say he simply participated in a 30-year-old practice. It strikes me by those comments as well as others that at least part of your defense is that this has been happening for a long time.
Well, yes.
How does the length of time justify current action?
Well, it's relevant in three ways, but I'd like to first address it in the form that using this backdating process that your representative used by way of response in the statute of limitations, it's relevant to that as well. People have been buying these particular bottles of restricted alcohol. And when I call restricted, there aren't many for available for decades and decades. The concept that that particular practice is somehow giving insiders a benefit that others don't get, and that people are being given a financial advantage is undercut by a statutory scheme that has overlaid this, that gives them rights to be able to purchase just like everyone else. The calling of this an ethics violation is very late in the day when the behavior has been lawfully allowed by our state legislators to allow them to purchase on equal footing. When you see that your own representatives or representatives from the state, when asked to opine whether the right to purchase is even a valid enactment, because everyone should be allowed to buy on equal footing. And the fact that this has been a practice that has allowed OLCC employees, just like every other person in the state, to get alcohol without any sense of secrecy. There's no under the table. There's nothing. People have been acting under what they perceive to be a statutory right to buy, and that they have believed is not cutting anyone else of their rights out. And that really the issue was to restrict it further by having a chance to purchase might be the problem, not the current problem.
Thank you. Other commissioners, questions, comments? If I miss your hand, I apologize for that. That's our system that sometimes doesn't always depict hands raised by teams. So please, if I'm missing somebody, don't hesitate to interrupt as Mr. Jancy did. Executive, one general question based on the proposal before us that you've advocated to us in your report. Can you summarize for us, for context, what their recommendation is, make preliminary findings of violations of ORS 244.0401, ORS 244.040 sub 4, and ORS 244.120 sub 1 sub C. Summarize what that means if we were to move in that direction, which we have not yet done.
Yes, so 244.040 sub 1 is the prohibited use statute, which would be to make a finding that he used or attempted to use his position to obtain a financial gain or avoid a financial detriment that would not otherwise be available but for him being in his position at OLCC. 244.040 sub 4 is the confidential information statute, which is use your position and the information that is confidential by statute or rule to obtain a personal gain. And then 244.120 sub 1 sub C is the confidential conflict of interest disclosure statute, which would require disclosure to the appointing authority. The recommendation of the investigative report is to find preliminary violations of all three statutes and move the case to a contested case proceeding or a negotiated settlement.
Thank you. And you'll anticipate this last one more question for me. Can you define for me, the word preliminary?
Yes. So when the commission at this stage makes a finding of violation, it is a preliminary finding of violation because the respondents have the right to request a contested case hearing before an administrative law judge. If that is done, after that proceeding, the administrative law judge would make his recommendation to the commission.
Back to us.
Back to
Right.
you. And at that point, you would make issue a final order.
Thank you. Any other questions, colleagues, comments? Before we head toward the next step in our process, which is to discuss how to proceed and then to proceed in some direction. I'm looking for comments from commissioners about how they lean today in light of all they've heard and read and reviewed over the weeks, not to mention just today. Alicia McCauley, Commissioner McCauley, please, I think see your hand up.
Yeah, thank you, Chair Fiscum, and thank you, Ms. Hoffman and Ms. Birch for being here. I appreciate your comments. I also appreciate the fellow commissioners' questions, and especially Commissioner Jancy. I'm not sure I don't have any questions, just more of a comment. And this may lean towards kind of the direction in which I'm headed. I'm really having a hard time with getting over or getting past that the public had an opportunity to know these things were available. Knowing that these bottles were kept in a protect from sale status, or, something, if you want to call it that. And the timing in which that might occur from when it moves from that status into inventory for people to know. So I'm leaning towards probably moving forward with this, but I'm open to comments or clarification if anybody would like to assist with that.
Mr. Chair.
Thank you, Commissioner. Hang on just a second. Thank you, Commissioner. I appreciate your comments. Just for a moment, any other commissioner have any comments in light of what you've heard from Commissioner McCauley? And if you do, this is your moment. And if you're not careful, I may call on you. Sorry. It's not a laughing matter. So I mean that very seriously. We need to genuinely make our comments and be known for the record. Ms. Hoffman, did you have a comment?
I did, because I didn't get a chance to respond earlier to the comment that was made to you. I need to address the sequence, because I think that it got muddled again when your advisor responded to what we said. And it came up again just now. When this product is embargoed and people don't have it online and it's being dealt with as a unaccessible product, there is no evidence in this case that anybody obtained bottles from the OLCC during that time period. People who obtained bottles, what the record shows, only obtained them once it had moved off of that status. And so this is a pivotal thing, and I think that's created some confusion. Once it is opened up to being distributed, it is no longer secret, and it is only at that point that individuals from the OLCC and the public started to get responses or inquiries regarding the presence of those bottles. So people from the OLCC had no advantage over anyone else.
Thank you. Mr. McCauley, you may have a follow-up. Please proceed.
Yes, thank you, Chair Fiskham. I guess I would ask, though, OLCC staff does have an awareness surrounding the timing of when those would be released, though, correct?
Sorry, I didn't hear what you said.
Mr. McCauley, would you repeat the question, please?
Sure. No, I just wanted to clarify, though, that OLCC staff would have the heads up knowledge of the time frame in which those would be released to sale, correct? So they would have a heads up.
That requires, that jump that you just made has not been developed in evidence in this case by the Department of Justice or your commission representative that there were breaches in that information. But they also wouldn't know that there were available bottles because the reserve stock that we are talking about may be committed to other people because it's kept in reserve to only satisfy people who won the lottery and for some reason weren't going to get their bottle. So they don't even know that there's accessible reserve stock until the dust clears after the lottery.
Mr. McCauley, anything follow-up? And if
No,
not,
thank you.
thank
No,
you very much
thanks.
for your questions. I want to make sure that other commissioners have a chance to make a comment, so I'm just going to name roll call for a moment to see, and if you don't, no pressure. Mr. Resendez, Gutierrez, any comments or questions from you? And if not, fine. Your call.
Well, other than just thank you for your presentation. I appreciate it.
Mr. Burke, are you online?
I am, thank you, and I have no questions or comment.
Thank you, sir. Commissioner Mason, are you back yet? I think I see your name. Not
Commissioner
back.
Mason is not back.
Okay, thank you. Commissioner Mettler, I don't know if she's back.
Commissioner Mettler has not joined the meeting.
Thank you very much. I appreciate it. Okay, that's all I have. Colleagues, now's the time for us to move toward a decision here. The step would be for one of our number to make a motion. All things considered, I'm ready for a motion.
Could I be impertinent and jump in for 1 sec?
1 second?
Yes.
I'm sorry, because if I hold you to 1 second, you're done. I'm sorry.
Okay.
I apologize.
Give you a minute.
I'm having fun with you, but
Yes, I know
please
you are.
proceed.
Mr. Sabasic, on a procedural issue as to how the OLCC works, wanted to make a single statement to explain it because he thinks there may be some confusion. Would you entertain that limited explanation?
Yes, ma'am, I would. I just want to emphasize that I'm not making, I don't want to force you to make a comment, Mr. Sabasic, in light of your earlier comments, which I respect and understand fully. If you choose to make this limited comment, please proceed.
Yeah, and I'm gonna try to do what my attorneys would. I'm trying to have their second voice in my head. But I'm not gonna make any statements on my behalf, but I wanna give my understanding based on my what I learned.
Please proceed in the next moment.
So the concept that only the people that had some special inside knowledge could get these bottles. I don't know if it's quite clear here, and I know there's a lot of things in the evidence that the evidence actually showed that's not the case. Because we have the Rick Clyde, which is the person that Janet mentioned, who was some priest's son at the coast of Oregon, asked for a dozen different, very hard to find liquor bottles. And if you look at what they are, because he says in his thank you email, they're all of them, as far as I know, were part of the lottery program. They're all very hard to find bottles. He specifically asked for them, and OLCC, Nikki, did a bunch of work and got it to him. And he's saying, thank you note, and he got it. These are hard to find bottles. So the premise that these bottles, and they were part of the lottery bottles. So the premise that nobody from public could do that is not correct. There was another email that I believe Ms. Hoffman referenced earlier, which is the ORLA. I believe it's Oregon Restaurant Lodging Association. Specifically, there's emails sent after the advertisement went out for a lottery. And they're asking, they're like, oh, we saw that there's advertising, there's lottery coming. We would like this many bottles of Pappy, this many bottles of this many, can we get any? And then there's emails from Nikki and Steve Marks, and they arranged and gave them. They got a bunch of bottles, Pappy, and this is people from outside. This is not employees of the state. So the premise that this only happens if you're a state employee or an OLCC employee is simply not correct. It's false.
Thank you, sir. Any other comments or questions quickly as we head toward a decision here, colleagues? Seeing and hearing no others, I will ask if the vice chair is prepared to make a motion.
I am.
And make a comment first or a motion.
I am, Mr. Chair. My motion is going to be to keep this process moving forward, but I'm going to make a motion to remove ORS 244-040 sub 1 the financial gain violation in light of the fact that the bottles were purchased. So with that, Mr. Chair, I move the commission find there is sufficient evidence that Bubba Subasic has violated ORS 244-040 sub 4 and ORS 244-120 sub 1 sub C, and that the commission adopt the investigation report as its preliminary findings in order that this case be moved to contested case proceeding or a negotiated settlement entered.
Thank you, Vice Chair. I want to make sure a couple things for the moment, colleagues. One, that you all understand the motion that has been made. And I'm going to assume, unless I see a hand raised, that you do understand the motion, including the difference between the motion as made a moment ago and the recommendation before us. If you understand that distinction, that's number one. Number two is a comment on that distinction. And I'm looking for comments from any of commissioners as well as the executive. You should feel free to make comment if you choose to. If not, you feel no pressure.
Obviously, it is the commission's discretion to act on that motion. Under the statute, 040 sub 1 and 040 sub 4 are separate provisions with separate standards.
Thank you. Commissioner McCauley, please.
No, I just want to say thank you, Chair Fiscam, that I appreciate Chair Thompson's recommendation, and I will support this motion.
Thank you.
Since you called me chair, I got one.
Thank you, Commissioner McCauley. I appreciate your comment. Any other comments from commissioners before we head toward a vote? Yeah, I'm going to do one favor for all of us, and I'm going to ask the vice chair to repeat the motion one more time, and then I will ask after that the administrator call the roll. Vice Chair, please repeat your motion.
I move the commission find there is sufficient evidence that Bubba Subasic has violated ORS 244-040 sub 4 and ORS 244-120 sub 1 sub C, and that the commission adopt the investigation report as its preliminary findings in order that this case be moved to a contested case proceeding or negotiated settlement entered.
Thank you, Vice Chair. Are you ready for the roll call vote? Not seeing any hands to the contrary, I will now ask the administrator to call the roll This relates to item 23-071 on our agenda, and the motion is made by the vice chair. Please proceed.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Piscom.
Aye.
Motion passes 6-0.
We now have the action by us. As a commission, thank you for your participation for the last minutes, if not a couple of hours, an hour or so. I want to thank our respondents and representatives for coming to our place today for this hearing. We appreciate your comments. I imagine we'll be seeing more of you as we proceed down the road ahead of us.
Likely.
So thank you for your participation today and for the tone of, for the respectful tone of your remarks. We appreciate that. Mr. Sabasic, thank you for being here. We'll just pause for a moment.
Break for lunch.
Yeah, we could do the following. I was going to suggest that we could allow our respondents to leave easily, and then we should break for lunch. We can come back in maybe during lunch and deal with a few other items on our agenda heading toward the adjournment today. So let's recess for the next few moments at lunch. State what the lunch is for us here in Salem.
There is a spread next door.
There is a spread in the conference room next door. We'd be happy to send some to all of you. We're online via online means if that works. Thank you. We're in recess for 5 minutes or so. meeting when our staff is ready.
The recordings are
Maybe-
on, Chair.
Okay, now you can do it.
The recordings have started, Chair.
Is it, we have enough people here? Have a quorum? Have a quorum?
Chair Burke is online. We need to re-allow his mic though. I just did actually. Chair, or excuse me, Commissioner Yancey's back. Commissioner McCauley is online.
And Cindy, get the ears is there looking at me, sort of. Okay, let's
Grab his camera on him.
reconvene the public session, July 11, 2025, and proceed through the rest of the agenda, starting with item 65 involving Jamie Wood. Investigator is Investigator Fenstermaker, who will make now a report.
Thank you, Chair Fiscum, Commissioners. I'm Casey Fenstermaker. Case number 24-482 PAM is an investigative report for Jamie Wood, board member for the Crook County Cemetery. This case was moved to investigation to determine whether there was sufficient evidence to indicate that Jamie Wood violated public meetings law when she and Velda Jones, another board member, met on July 18th, 2024. The cemetery board is a 3-person board, which means that when Jamie Wood and Velda Jones got together to discuss the district manager's employment, they constituted a quorum, since there was a quorum discussing cemetery business. That resulted in a meeting as defined in public meetings law. Since the meeting happened in private, because the meeting was not open to the public, because the meeting was not properly noticed, and because no meeting minutes or recording of the meeting was taken, the meeting resulted in multiple violations of public meeting law. Therefore, there is a preponderance of evidence that Jamie Wood violated ORS 192.630 sub 1, ORS 192.630 sub 2, ORS 192.640, and ORS 192.650 sub 1. And as a result, the commission should make a preliminary finding of each of those provisions.
So the respondent, Jamie Wood, is not with us.
In fact, yes.
Ms. Wood, I see your name on our list. Right now, you may be on the phone, but you are muted. *6 to unmute yourself.
She's on Teams.
You're on Teams, pardon me. You're on Teams. Jamie Wood, are you there and can you hear me?
Yes, I can hear you.
Thank you. We've just had a report. This is Dave Fiscum, Chair of the Ethics Commission. We've just heard a report from the investigator involved in this matter, our investigator, Casey Fenstermaker. This is your chance to make any comments you choose to make to us in the next moments. So please introduce yourself for the record and tell us what we need to know from your perspective.
Okay, my name is Jamie Wood. I was or still am actually, a board member on the Crook County Cemetery Improvement District Board. I would like to clarify, and I know that the law is very black and white on this. However, I would like to say that exigent circumstances were involved in this particular matter. Velda Jones had resigned on Tuesday. I can't remember the date, in July. And then she rescinded her resignation on Thursday because of an SDA rule that allowed for that. When I found out what had been going on between Corey Nelson, which is the manager that we released, and a board member that had been on the board for less than a week, who Mr. Nelson brought on board in order to keep himself from getting fired, I called Velda because I didn't know what else to do. Miss Basie, Roxanne Basie, was the board member who had been on board for less than a week, and Mr. Nelson had gone about, they had just basically gone on a tear, cutting out other board members as they saw fit, changing meeting times and whatnot for the next month. They approved on their own $20,000 above and beyond what the board had already approved for paving, and then proceeded to have the paving work done. Then once Velda resigned, I called and let Miss Basie know that Velda had resigned. Roxanne and I didn't much care for each other. So I proceeded to tell her that she said, well, I've already got Velda's replacement picked out. She didn't discuss it with me. They didn't open it up to the public, nothing. She's just like, I have her replacement. And I said, no, we weren't going to do that. That was not the proper way to replace a board member who had resigned, and we weren't going to go about that. If she and I could not agree on a person, I said, we can always ask the county commissioners to install someone in Velda's place. Instead of doing that, Roxanne chose to resign on Thursday, trying to save Corey's job because they had already started the paving process, and they knew that they did not have a majority of board approval to do that. And so when I found all of these things out, I called Velda, told her what was going on, and begged her to rescind her resignation and help me fix this. We weren't trying to have a meeting outside of public view. That was never my intention when I called her. I was just looking for someone to help me, and I was trying to give Velda reasons to rescind her resignation. She originally resigned due to health reasons brought on by stress caused by Mr. Nelson with a cleanup that he did that caused severe public outrage. And then there was a gentleman who was a felon who was making threats. And Velda was terrified that this gentleman, Mr. Walsh, would come up and set her house on fire as he had done in the past with our district attorney. And so, like I said, when I called her, it was to give her enough reason to, one, want to rescind her resignation, and two, to actually see if she would do it. We were not trying to have a meeting outside of the public or non-noticed or no meeting minutes or any of that. We weren't thinking like that. And I know the law is very clear because she rescinded my phone call constitutes a supposed violation of the law. But after that situation, I have basically, Velda has since again resigned. I instituted more policies that we did not have back then. For example, if something were to happen in this particular day and age, I would first get in contact with the district's legal counsel. And we did not have that option back then because we didn't have legal counsel. I don't do anything unless he, says it's okay to do it. And, here's how we're going to proceed. This is not a mistake I will ever make again, is basically, what I'm getting at.
Yeah, thank you for your comments to us. We appreciate it. Any questions for our respondent, Miss Jamie Wood?
I have a question.
Hearing and seeing only one. Commissioner Thompson, please.
Thank you, Ms. Wood. So the phone call in question, did that happen when Ms. Jones was not a member? Like she had resigned but not rescinded the resignation? I'm trying to figure out what her status was at the time.
Yes, the Velda resigned on Tuesday morning. I called her on Thursday morning after I found out all of the details about the paving and that Roxanne had tried to basically resign without notifying us properly. She sent her resignation to the county commissioners. And so by the end of the day, I was going to be the only board member left. And we had this big mess. And so at the time when I called Velda, she was not currently a board member. I called her to try to get her to rescind her resignation, but she could have just as easily told me, no, I don't want to get involved.
Mr. follow-up?
I guess my question is for Ms. Fenstermaker or Ms. Myers. I mean, was she a public official on Wednesday? I mean, I know it's getting off in the weeds and I apologize for that, but was Ms. Jones a public official on Wednesday or Thursday morning before she rescinded her?
I mean, if she had resigned on Tuesday and didn't rescind it now, the idea of rescinding it suggests that you're not solely off the board in a sense, but you could certainly reach the conclusion she was not a public official for that very period.
36 hours.
Yeah,
So if that's the case,
then there would not be a
there
violation.
wouldn't be a violation. Mr. Thompson, you ready to make a motion?
Kind of like to hear what some of the fellow commissioners think about.
Fellow commissioners, have you heard our brief discussion in the last moments about these two matters? Matter involving Jamie Wood, number 65, and Velda Jones, number 66, relative to whether Ms. Jones was actually a public official at the time or not. It appears she was not. Executive?
The one thing I would add, I do know that Andrew, in working the investigation, had tried multiple times to contact Velda to talk to her.
Without
Simply
success.
was not getting any
Okay.
response.
Any other comments from commissioners? I don't see any right now. Mr. Thompson, I'm prepared to dismiss if you are.
Yeah, I am. Okay. For agenda item 24482, I move the commission dismiss the complaint against Jamie Wood.
Colleagues, you've heard the motion. Any questions? Hearing for the moment and seeing none, based on the rationale that one of the persons involved was not a public official, the motion stands. The Administrator will call the roll, item 65 on our public session agenda.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Chair Fiscom.
Aye,
Motion passed 6-0.
thank you. With regard to item number 66,
It's the same report.
it's the same report.
Same report and with these additional facts for your consideration.
Thank you. Vice Chair, please, item 66.
For agenda item 24483, I move the commission dismiss the complaint against Velda Jones.
You've heard the motion. The Administrator will call the roll, please. Item 24-483.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Okay, colleagues, forging ahead, we will now move through the agenda items to the miscellaneous items section. And there are 4 items for our review there. The first one is going to be provided by the Executive Director, a motion to suspend. Go ahead, please.
So, Commission, item 67 involves a case against David, I think it's David, Mr. Younger. The Commission opened the case on its own motion, did the preliminary review, and then once it moved to investigation, suspended it because there was a pending criminal investigation and prosecution. And so it was suspended until March or April. At that point, the criminal prosecution had concluded. He was found guilty or reached a plea. We reactivated the investigation, but we have since been informed and notified that he has appealed the judgment against the criminal judgment against him and his sentencing there. And so given that is a continuation of the criminal matter, we are asking the commission to resuspend the investigation so that we can preserve the time needed.
Any questions, colleagues? Hearing and seeing none, Vice Chair.
Mr. Chair, I move in the case number 24052, that the commission suspend the investigation pending completion of the appeal and the related criminal case.
Administrator will call the roll. Administrator will call the roll, please. Item 24-052.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Okay, item 68, own motion, commission advisory opinion, executive, please.
So this request or proposal to you is asking that the commission direct me on its own motion to draft and issue a commission advisory opinion. This relates to the commission's construction and interpretation of ORS 192660 sub 2F. The confidential information, specifically as it relates to confidential or privileged attorney-client advice. In the past, the commission, in both cases and advice, has advised that there needs to be a written record, like a written legal memorandum, in order for a group to hold an executive session under 2F to get attorney-client privileged advice. As was pointed out months ago when we did our public meetings training, and Shanoa Payne asked the question, well, if we are in a commission meeting and we're asking our attorney for advice on a case or something else, we don't have a memo from the attorney at that point. We're in that section. Yes, best practice, if you know you're going into executive session under 2F to get privileged legal advice, best practice would be for an attorney to prepare a legal memo, as ours did today. But the point of 2F is to allow members of the public, members of a governing body, the same protections that members of the public would have to get legal advice from their counsel and without waiving the confidentiality of that advice. And so I think the legislature did amend the statute to have it say information or records, and I think it would be more appropriate for the commission to issue an opinion clarifying that 192660 would apply to confidential attorney-client advice, even if it were not written.
Given orally.
Yeah.
For example, in the meeting. Colleagues, questions on that for the executive? For what it's worth, I'm in favor of this because it makes more sense to me. Writing's better, but oral advice may be just as meaningful in certain moments of time, and we need to depend on it. So
the need for it to be in an advisory opinion is simply because we have issued prior advice and opinions and cases. And so this is a shift in the commission's construction of the provision.
Comments, questions? Hearing and seeing none. Vice Chair, are you prepared?
Yep. Mr. Chair, I move that we direct our
The motion?
Wait.
Oh, yeah, you might as well. Go ahead, sorry.
Mr. Chair, I move that we direct the executive director to draft a commission advisory opinion around ORS 192.660 sub 2 sub F, and whether it is necessary to have privileged information in executive session be in written form or not. I do.
Thank you. You heard the motion. The administrator will call the roll on that motion dealing
Commissioner
with own motion, commission advisory opinion. Please proceed. Thank you.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Thank you. Next item is a trainer's report, which we have in writing. Anybody want to make a comment on that?
Yes.
Ms. Hefner, please.
Thank you, Chair Fiscom and Commissioners. This is Stephanie Hefner, the Training and Curriculum Coordinator for OGAG. In your books, you will see our mid-year report. So it's a little bit of a mix of what we've done in terms of trainings completed, both in person and webinars between this and the last report. But then when we go a little bit further into it is looking at the first 6 months of this year. And you will see that we have delivered more trainings in 2025, more than double the trainings that we delivered in 2024, which, so we're still on that very steadily increase of demand for trainings. Granted, this year we did have public meetings law training. We see a huge demand for that. So that's not shocking. And along those lines, we also had like 121% increase in training participants this year over last year so far. And our fall is already quickly booking up. So this year is going to be pretty substantial. Just to kind of give you the high level view, which I did put in here, but I did run the training data right before the biennium ended. So these numbers are actually higher for this current last biennium. But for the 2021-2023 biennium, we trained a total of 2,858 participants. However, during the 2023-2025 biennium, we trained more than 10,200 participants, which is a statistically relevant data point, I believe, no matter which way you look at it. We are continuing to see the importance of both online and in-person trainings. We've offered customized trainings to 27 entities in 27 of the 36 counties so far this year, and those have been online and in person. And since we started public meetings law in trainings last October, we have actually reached, for public meetings law specifically, we have reached public officials in all counties of the state since October of 2024 for public meetings law trainings through in-person and webinars and customized online ones. So I think that demonstrates the value and the interest in our trainings. We are doing more public meetings law trainings than ethics currently, but even in this last reporting period, month, we did 8 customized public meetings law trainings. We did 5 government ethics law trainings. So there's still a demand as well for those. And we're working on outreach plans for next year to ensure that we are still focusing on ethics and that doesn't get left behind.
Thank you. Good work. Comments, questions, colleagues? Hearing and seeing none, the final item on our agenda is the executive director's report, which you have in writing. Executive, please.
So before I jump into the report, I do want to take the opportunity to answer Commissioner Mason's question from the work session this morning, which is, quickly looked it up, that
Commissioner Mason's not here, so we'll convey that to him. Go ahead.
That it was in 2007 with Senate Bill 10 that the penalties for violations was increased from 1,000 to 5,000.
Good. Thank you.
So my report, one, I would like to praise the training team. As their report indicates, they have just done such a tremendous job and increased the scope of our training program compared to where it used to be. Budget, we have ended the biennium with a surplus of a little over 714,000. That surplus consists basically of operating funds because it takes a while for the assessments to come in. So we have about a 3 to 4 month carryover. And then approximately 300,000 is money that was set aside, that is money specifically allocated for the CMS EFS system upgrades or replacement. The 25-27 budget passed and was signed by the governor on June 16th. Our biennial budget was increased to $7,005,742. The budget included all 4 policy option packages, which were specific funding for our increased DOJ fees, position reclassification. Yeah, he's very expensive. Position reclassification, that was Becky's position, increased funding for training and additional funding for the CMS upgrades. It really isn't nice to call them upgrades because really it's going to be a new system. But so all of that has been authorized and is in the works. In the legislative session, we had 2 bills that were passed and were signed by the governor. What is in my memo may be wrong. I put in that they will go into effect 91 days sine die. But then I got something from DAS or someone that said effective date January 1, 2026. I'll figure out which it is. In either event, I don't think it matters. They'll go into effect. And then the non-filer info is undoubtedly out of date. I think the last time I checked with David, we were down to 7 or 8 SEI filers and less than 4. Yeah.
Okay, good work. Colleagues, thanks for your patience with a long agenda today. We started off quickly and ended up slowly. Any other comments for the good of the order before we adjourn? Thank you for your patience with the agenda, and those online, thank you for being with us. That said, we're now adjourned until a couple of weeks. We stand adjourned.
Have a good weekend, everyone.
Thank you. Have a good one.
Thanks, everyone.